Is that a word, transcriptionist? Is that your final answer? Okay. We have reestablished. Okay. And everybody is back on board. Yeah, very good. Well, thank you. So having no more questions, any recross?
Just a couple questions.
Oh,
Chair.
sure, please.
Mr. Collins, do you agree that it's important for transmission planning to have generators have a capacity limitation?
I think it's important as a transmission planner to, yes, to be aware of what the, maximum capacity of a generating unit that is providing capacity to the utility.
And so when you're saying that there's a 35 megawatt average capacity rating for KELP, that's not setting a limit, right?
No, it's not. The KELP QF can provide up to, approximately 42 megawatts, and that's how the interconnection was originally built.
So do you agree that 42 megawatts is about 20% higher than the 35 megawatts represented in the original PPA?
Your math seems correct. But again, the 35 megawatts is an average number, and it's a contractual number, not a limit on how much output the KELP QF can produce.
Do you know what would happen if generators on Northwestern System operate about 20% above their capacity ratings?
I do not know without doing any modeling, but again, the KELP QF interconnection equipment has been able to handle more than 35 megawatts output of delivery to Northwestern.
Would you agree that if all generators were allowed to exceed their capacity ratings by 20%, it would be probably near impossible for Northwestern to balance its system?
Well, it depends on whether Northwestern's selling that, that energy outside of its balancing area. There's a lot of assumptions that you have to make to answer your question.
It wouldn't be very good planning purposes, right? To allow generators to exceed their capacity ratings.
Again, it depends on the assumptions of what you're doing with that power. Is that being utilized in the balancing area or being exported outside of the control area?
And again, I think we already established this, but KELP never reached out and requested interconnection up to 42 megawatts.
Are you asking me back in, the 1980s, or you're asking me currently?
As far as you're aware.
As far as I'm aware, there's never been a limit agreed to in the PPA that was entered into by both Northwestern and KELP.
Thank you.
I just need a clarification here for a minute. You're talking about capacity limits and nameplate. Is there a difference between those? And if I'm confused. You said there's a nameplate that's 35. You said that's an average. I'm not familiar with a nameplate being an average, but it's an absolute maximum. I'm confused on the terms here. Can you help me?
Sure thing. Well, the actual gross nameplate rating of the KELP QF, according to my understanding, is approximately around 46,000 kilowatts. So net of parasitic load, that's electric output that has to be used to operate certain equipment at the power plant. That would be a nameplate rating on a net basis of approximately 42,000 kilowatts or 42 megawatts. The 35,000 kilowatt number or 35 megawatt number, that is a contractual number that was put into the PPA. That's an average number. So the very nature of an average indicates that there is an upper limit, above 35 megawatts. I believe that the 35 megawatts, was at 100% capacity factor. That would be equivalent to the energy limit that was contained in the existing PPA. And that was, I think, one that Mr. Gorman had referenced is over, I think, 306 million kilowatt hours. So the 35 megawatts at 100% capacity factor would give you the energy limit on the existing PPA. Going forward, we're not wanting to have that limit anymore. We're basically wanting, the company to, purchase all the output of the existing of the KELP QF. But again, the 35,000 kilowatts is an average number, annual contract capacity,
Mhm.
and it was measured by measuring the 11 highest monthly capacity outputs by KELP. And again, it has operated above 35,000 kilowatts. And to the best of my knowledge, there's been no issues with the existing interconnection equipment that KELP QF has in place. And again, it has delivered in excess of 35,000 megawatts or 35,000 kilowatts.
Thank you. That clarifies a lot for me. It's the first time that I'm aware of that I heard any reference to the gross maximum nameplate of 46%. And then after the interior uses down to 42, that clarifies a lot of things. Thank you.
You're
for
very, very
that.
welcome.
Mr. Brown,
No cross. Thank you.
redirect.
Yes, thank you. Good afternoon, Mr. Collins.
Good afternoon.
Let's go back, starting with the questions that Mr. Hensley posed. You recall a series of questions about the original PPA and the definition of the term capacity and what that means in terms of the interconnection. You recall those questions?
I do.
I believe you testified that the PPA was subsequently interpreted in litigation before the Montana Public Service Commission. Do you recall that, sir?
I do. Yes, back in, I believe, 1991.
All right. Can you please turn to Exhibit BCC2 from your rebuttal testimony?
Yes, I'm there.
All right. As a general principle, let me just ask this question. If you have a contract between the utility and a counterparty, and that contract is subject to litigation at the commission, and the commission then renders a decision about how the contract is to be determined, what, in your experience, would control? The original contract that was disputed or the commission's order in the dispute?
Objection. It's calling for a legal conclusion.
Argue no more than the other legal conclusions we've been offering so far, but if the witness is uncomfortable answering, I'm happy to defer that. Very good. All right. Let's take a look at the proposed order. Do you have that in front of you, sir?
The proposed order, I'm sorry, Mr. Nelson?
Yeah, Exhibit BCC 2.
Yes, I do. Yes,
All right. And this is the commission order from 1991 in the docket that you mentioned?
that's correct.
All right. Can you take a look at page 19 of 28 of that exhibit, please?
Yes, I'm there.
Can you please read, you see where it says order?
Yes.
Can you please read the paragraph?
It is hereby determined that under the agreement here at issue, as amended, MPC is obligated to purchase from the KELP project at rates determined in the agreement as amended, a maximum of 35,000 kilowatts of annual contract capacity and a maximum of 306,600,000 kilowatt hours of annual contract energy.
So when you indicate that the contract as it relates to 35 megawatts, 35,000 kilowatts is intended to be an annual figure based on the average, is that consistent in your mind with the language from the commission order?
Objection. It's calling for a legal conclusion. I don't mind if he reads what these orders says, but if he's trying to interpret the orders, that's calling for a legal conclusion.
Asking him to interpret the word annual contract capacity, which is the exact same word that Counsel for Northwestern was asking him to interpret in a different context.
All I did was ask him to read what the contract said. I didn't ever ask him to provide an opinion on it.
I'll overrule that. It's just if these are conditions and terms that are well known within the industry, within your expertise, one need not have the expert testimony of it being an attorney to testify of things that you ordinarily deal with all the time.
Yes, I'm very comfortable. One of my jobs at Brubaker Associates is to help negotiate power contracts between utility customers and their utilities.
Yes.
So the question, Mr. Collins, is as you, from your expertise, consider the word annual contract capacity, can you explain how, from your understanding, that is an average term instead of a maximum instantaneous calculation?
Yes, it's my understanding that annual contract capacity is a PPA term, and that is defined as being measured by looking at the 11 highest monthly capacity during the contract year.
Can you go back to Exhibit BCC1 and in particular page 15 of 65 of that exhibit, and let me know when you get there.
Yes, I'm there.
You recall a question from Mr. Hensley about section 8.1 of that agreement?
Yes, I recall that.
Section 8.1 imposes obligations on the seller, correct?
Yes, that's correct.
And in this agreement, who is the seller?
It's my understanding that the Kelp QF is the seller.
And it's the obligations that I believe you read with Mr. Hensley was that the equipment, and I'm now looking at the third line from the bottom of that paragraph, the equipment shall be of sufficient size and capability to accommodate the delivery of capacity. Do you see that, sir?
I see that, yes.
In your mind and in your experience, does the term sufficient capacity create an upper limit on what Kelp can size its facilities to deliver to Northwestern?
Yes, that does.
Yes, again, make sure you're right. They have to be sufficient to do.
Objection asked and answered.
Yeah, okay, but let me try this again. What do you do when you get in that pickle? All right. What does the word sufficient mean, Mr. Collins?
Sufficient to me means it has to be adequate to handle the delivery of the capacity generated by Kelp for delivery to the Northwestern system.
Does the word sufficient necessitate that, but let me put it this way, in order to be sufficient, is it possible that you have more than is necessary? Could that also be sufficient?
Yes, it could be.
Okay, so sufficient means you just can't have less than is necessary, right?
Right. If you had less, you would not be able to deliver that amount of capacity that you generate and deliver.
Okay, so in this context, 8.1, which applies to the seller, simply requires that the interconnection be sufficient. So there's enough of it, but if the seller wants, there could be more than sufficient capacity, correct?
That's correct.
8.1, though, does not apply to the buyer, originally the Montana Power Company, now Northwestern, correct?
That's correct.
Is there anything in this agreement that puts a limit on what the buyer's interconnection facilities must be sized to accommodate?
I am not aware of such a requirement.
So let's take a look at what has actually happened. Can I ask you, do you have Mr. Gorman's testimony in front of you?
I do.
All right, can I ask you to please look at his rebuttal testimony? It's Exhibit Kelp 3. Sorry, I've lost my location. Hold on just a second, please. Oh, that's my problem. Sorry, it's exhibit 3, but it's the exhibit MPG 3. Direct testimony, exhibit MPG 3. Thank you.
Yes, I'm there.
All right. Now, in questioning from Mr. Hensley, you recall discussing, setting aside the contract, what the actual delivered capacity was over time, and in particular in the years 2007 through 2021.
Yes.
All right. So what I'd like you to do now is, can you please go, well, let's just take this one at a time. If you look at page 2 of that exhibit, do you see the year 2007?
Yes, I do.
Would you agree with me that every month that year, the capacity actually delivered to Northwestern exceeded 38.8 megawatts?
Yes, that's correct.
And again, in 2008, the monthly peak capacity was between 38 and 39 megawatts every month, correct?
Yes, that's correct.
2009, monthly peak capacity between 38 and 39 megawatts, correct?
Correct.
We skip forward to 2012. Do you see now that we have in November and December, capacity gets to 40 megawatts?
Yes, that's correct.
2013, 14, and 15, again, every month, the capacity actually delivered at peak was 39 megawatts or more.
Yes, I would agree.
Next page, 2016, 17, and 18, with the exception of a outage that occurred in 2017. Again, 39, some 40 megawatt monthly peak capacity, correct?
Yes, that's correct.
And then last but not least, 2019 through 2021, again, every month, capacity, maximum peak capacity, monthly peak capacity, 39.39 megawatts, 40 megawatts, with some exceptions in October and November of 2020. Is that correct?
Yes, that's correct.
So based on this data, what can you conclude about whether or not the interconnection facilities that currently are in existence are capable of providing, are capable of accommodating capacity deliveries in excess of 35 megawatts?
Yes, based on this data, the current interconnection equipment is well suited to provide delivery of capacity well in excess of 35,000 kilowatts or 35 megawatts.
Right.
$35, yes.
Mr. Collins, I placed in front of you what has been admitted into the record as the response to Northwestern number 37. Do you see that, sir?
Yes, I do.
And that exhibit contains an attachment. Do you see that?
Yes.
And can you tell me, well, do you see that on that attachment is a collection of documents from the annual report of Northwestern Energy?
Yes.
And can you confirm that what is included in that is an excerpt from the annual report, which is Schedule 34?
Yes, I do see that.
You understand that this schedule, do you see the title of that?
Yes, Schedule 34, Sources of Montana Electric Supply.
All right. So if I could ask you to turn to page Well, we'll start on page one. What year is the report on page one from?
Year ending 2021.
And in that year, do you see that Northwestern provided the commission no information about the average monthly billing demand for a variety of qualifying facilities, correct?
Correct.
Now, if we go back a year to 2020, Northwestern has now reported to the commission in Schedule 34 the average monthly billing demand for a variety of qualifying facilities, correct?
That's correct.
And for 2020, what is the reported average monthly billing demand for Colstrip Energy Limited / Montana One?
That is shown at, I believe, line 25 on the schedule, and it is 40.2 megawatts.
And that figure shows it as an average, right? So that presumably that could mean that in some periods it was higher and some period it was lower, correct?
Yes, that is the very nature of an average. There is likely a number that is higher than 40.2 megawatts.
And this is information that the utility reports to the commission, correct?
That's correct.
What did Northwestern report to the commission the capacity of KELP was in 2019 on the next page?
In 2019, it was reported as 40.4 megawatts.
What did the Northwestern tell the commission the KELP? Now, in this case, in 2018, I'll just note the title of the thing changed. It now goes to annual peak. You see that, sir?
I do.
So what does Northwestern report as the annual peak for KELP in 2018?
40.2 megawatts.
And what does Northwestern report to the commission is the annual peak in 2017?
40.1 megawatts.
So again, based on the information reported by Northwestern to the commission, what can you conclude about whether Northwestern's interconnection facilities are capable of receiving capacity from KELP that is consistently over 40 megawatts?
Yeah, it appears based on this material that the interconnection is designed to provide the delivery from the KELP QF well in excess of 35 megawatts.
You have Miss Mueller's testimony with you.
Yes, I do.
I ask you to pull that out. Let me know when you have those.
I have it. Yes.
Ms. Mueller attaches to her testimony Northwestern's proposed interconnection agreement. Is that correct?
That's correct. I believe it's exhibit AMM-1.
Thank you. Could you please turn to that exhibit?
I'm there.
All right. Can I ask you specifically to turn, and you'll see this at page 47 of 92 in the upper right corner, and ask you to turn to section 9.6 of that agreement.
I'm there.
You recall a series of questions from Mr. Hensley about whether or not KELP's proposed interconnection agreement included protections or requirements relating to reactive power and frequency response.
I recall. Yes.
As you understand it, under Northwestern's proposal, are the reactive power and frequency response requirements that Northwestern is recommending reflected in section 9.6 of this agreement?
Yes, I believe that is correct.
Further, would you agree with me that there is another provision on page 60 of this agreement that is section 11.6? And let me know when you see that.
Yes, I'm there.
Do you see that that section 11.6 includes a discussion of payment for compensation related to reactive power which stems from the Article 9.6.3. Do you see that, sir?
Yes, I do see it.
Okay. If the commission elects to either incorporate the interconnection requirements into the PPA or uses KELP's proposed interconnection agreement, is KELP willing to add to that document the language in section 9.6 of Northwestern's LGIA, and as applicable, the language of 11.6 relating to compensation for 9.6.3 to alleviate any concerns Northwestern may have about KELP's going forward requirements relative to reactive power and frequency response?
Yes, that's my understanding. They are willing to do so.
Now, one slight nuance I'll just cover with you. Can I ask you to please turn to 9.6.4.3, which you'll find on page 50 of 92.
Yes, I'm there.
Do you agree with me that if we incorporated this language into the or into the GIA that you recommend, that it would be unnecessary to incorporate 9.6.4.3 insofar as KELP is not a facility regulated by the United States Nuclear Regulatory Commission
That's correct.
and is not a behind the meter operation that's also discussed there, correct?
Correct.
Would you also agree with me that it would be unnecessary to incorporate 9.6.4.4 on the next page insofar as KELP is not an energy storage resource?
That's correct.
All right. Lastly, I want to turn to an area that you discussed with Mr. Hamilton. And in particular, I would call your attention to the proposed, the red line of the PPA that you attached to your testimony. You recall that?
Yes.
I apologize. I think that's exhibit 4, maybe. Red line is. Where is the red line? Oh, it's not attached to your testimony. It's in the
was-
discovery. That's what you're telling me. Okay, well, let me just ask this question, see if we can do it without looking at it. And if we can, then I'll find it. I apologize for having lost track of that. In the red line of the PPA, would you agree with me that if the commission, instead of putting the interconnection agreements in the PPA, decided instead to do a separate interconnection agreement, that you would have to change a bunch of that red line in order to accommodate the split between the two agreements? Is that fair?
That's fair.
Thank you. I have no further questions of this witness.
Thank you. And I don't know if it's a prerogative of the chair to ask another question, but I'm going to do it anyway.
Please.
It seems like my understanding of the original contract was that it required Northwestern to buy 35 megawatts and for KELP to provide 35 megawatts. However, on a routine basis, a regular basis, what was actually accepted by Northwestern was far in excess of that 40.1 to 40.4 megawatts. And so if the contract called for 35 megawatts, under what conditions did Northwestern and KELP do a buy-sell agreement on that excess power? Is it covered at all by that original contract as far as you're aware?
Well, I believe the 35 megawatts set the limit on the energy that was purchased by Northwestern. And I may have misspoke earlier when I said 302 million. I think it's more in the realm of 306 million kilowatt hours. So if you take the 35,000 kilowatts, times the 100% load factor, or capacity factor, which is basically providing 35 megawatts every hour of the year.
Mhm.
That would result in the 306 million kilowatt hour limit under the existing PPA. So to the extent, so again, that was on the average. So the extent that, that Kelp delivered more than 35 megawatts, again, as long as Kelp was within the limit of the 306 million kilowatt hours, they could provide capacity in excess of the 35,000 kilowatts.
So the line of questioning earlier by the Council for Northwestern asked if under the new PPA that it said Northwestern could be, or Kelp could be requested by Northwestern to provide more power, and that they said what would happen if it didn't, if Kelp said no. The answer was whether or not it's economically feasible. But looking at the past history, it seems like Kelp has been more than willing to accede to any requests of Northwestern, and that shouldn't. I should think that that's indicative of the nature of the relationship and wouldn't change. Is that your understanding as well?
Yes, it's my understanding that Kelp can continue to provide in excess of the average, 35,000 kilowatts. It should be able to provide, those levels of capacity that Mr. Nelson and I walked through on those reports. Anywhere in the the realm of 39 megawatts, 40 megawatts. That shouldn't change going forward.
And when Northwestern asks Kelp for more power, Kelp might be inclined to say, "Yeah, that's what we do." That's exactly, you bet.
They're in the business to sell megawatts.
Right. Thank you.
Chairman O'Donnell, I think some issues just came up in your cross, and I would like an opportunity to just
Absolutely.
pretty limited cross on the things you were saying there. Right?
Absolutely.
Mr. Collins, I just have a couple more questions for you there.
Okay.
So you were saying, I think you just told Commissioner O'Donnell for those years where you exceeded the 35 megawatts, that you did so because it was an estimate, because the original contract was an estimate, right?
The original PPA contained an annual contract capacity that was based on 35,000 kilowatts, which was an average number.
An average. Okay. Can you please go to your exhibit BCC 2, page 15?
BCC 2, page 15. Yes, I'm there.
Go to the very bottom, please. That last two sentences from the bottom. Can you read those out loud for the commission, please?
The last two,
Or sorry, the last three sentences.
beginning with sections.
Yes, please.
Sections 1.6, 1.7, and 3 set a maximum, not a guaranteed delivery under the agreement of 35,000 kilowatts. That 35,000 kilowatt cannot fairly be interpreted as an estimate. The maximum capacity of facility is 35,000 kilowatts.
Thank you. And are those sections 1.7, 1.6, 1.7, and 3? That's referring to the PPA terms that we talked about earlier, where you said that actually had an average, right?
That's correct.
Okay. And then I believe you also just told Commissioner O'Donnell that in those years where Kelp exceeded those 35 megawatts, that Kelp was selling to Northwestern. Is that your testimony?
I'm sorry, could you repeat the question?
Commissioner O'Donnell asked you about those excess capacity and all those documents where it said it was over 35 megawatts. And I believe you told Commissioner O'Donnell that those were sales to Northwestern upon Northwestern's request.
That was capacity delivered to Northwestern under the existing PPA.
You're not aware that those sales were to other parties?
I'm not aware.
If Kelp represented in discovery that those excess sales were made to other parties and not Northwestern. Would you have any reason to dispute that?
Objection assumes facts not in evidence.
Okay, I'll pull up the data request.
And to be clear, I'm objecting to the use of the word excess sales. The record will show that during many months of the year, Kelp delivers more than 35 megawatts at an instantaneous moment to Northwestern. We'll show that they do that
I'm going to
until
object.
they get to the contract
I'm
max.
going to object to
then
council's
there
providing
is-
testimony.
Right.
I'm just going to object because council is providing testimony here.
Try to explain my objection. And then there is a different kind of excess sale. The use of the word excess is confusing. There is sales to Northwestern that exceed in an instantaneous basis the 35 megawatts. And then different excess sale that council is referring to. And so his use of the word excess is misleading and confusing, and I object to that on vagueness grounds.
Mr. Chairman,
Yes, Commissioner.
could you indulge me and have the court reporter read back the last thing that was said by counsel for Northwestern Energy, please? That led to this colloquy, that led to the objection.
I was going to ask the council to rephrase the question, but let's go back to what the actual question was. So, Mr. Hensley, based upon the confusion of the use of the word excess, could you rephrase your question, taking into account the confusion that the use of the term had to your,
Sure, Commissioner O'Donnell. Kelp. Has Kelp ever requested Northwestern to purchase more than its contracted capacity limit?
Kelp has delivered more than the average 35,000 kilowatts to Northwestern.
You're saying that's to Northwestern for Northwestern's consumption?
Yes, I mean, I'm looking right now at attachment NWE-35, page 1 of 81. And this is a Northwestern Energy Montana qualifying facility payment invoice. And the generation kilowatts listed for Kelp are 39,398 kilowatts. So that's in excess of the 35,000 kilowatts.
So you're saying that was all sold to Northwestern?
Well, this is a Northwestern Energy Montana qualifying facility payment invoice.
And are you saying Kelp was never sold to any other third parties?
I have not looked at any other sales to other third parties. I've only focused on the sales to Northwestern.
And are you saying that again, if there's documents in discovery, and these are in the record, they were introduced at the beginning of this hearing that demonstrate that Kelp was selling to other parties, would you have any reason to dispute that?
I would have no reason to dispute if you have documents showing sales to other parties. But again, I have not looked at those that request responses, and I'm unfamiliar with any other sales that Kelp QF has made.
Okay, we've got the data responses in the record, so I'm good.
thank you.
Redirect.
Yes, Mr.
Yes,
Nelson,
please.
yes.
Let's try to unpack this, Mr. Collins. Would you agree with me? And please go back to exhibit BCC2, page 19 of 28, which is the commission order following the dispute about how much energy and capacity the parties will buy and sell. Do you have that in front of you?
I do. I have it right here.
Okay. So that order says, because I think it would be helpful to pack this up, that the contract contemplates a maximum of 306,600,000 kilowatt hours of annual contract energy, correct?
That's correct.
If you divide 306,600,000 by 8,760, which are the number of hours in the year, I'd be correct that the result of that would be 35,000.
I believe I have done that math and I would agree with you. Yes.
Okay. So what this contract contemplates is that Kelp could provide 35 megawatts every hour of the year, resulting in a maximum delivery of 600,000 kilowatt hours of energy. That's a possibility, correct?
Objection, he's asking the witness to interpret the contract that this commission has already interpreted. And he just read those provisions from the prior order.
Overruled.
Yes, they were to provide 35,000 kilowatts every year. Oh, I'm sorry, every hour of the year, 8,760 hours. That would result in the 306 million kilowatt hour energy number that you referred to.
Now, is it also possible to operate within these limits as annual limits and provide more than 35,000 kilowatts of capacity in the first 11 months or 11 months and change of the contract, and then stop selling entirely once you reach 306,600,000 kilowatt hours, shut it down for the last 3 weeks of the contract year. So at the end of the full year, you've delivered no more than 35,000 average kilowatts of capacity and 306,600,000 annual kilowatt hours.
That is indeed a possibility.
And is it your understanding that that is exactly what has in fact happened over the course of dealing between Northwestern and Kelp, that Kelp has overproduced in the beginning of the contract year, and then once they reach that contract limit, shut the plant down and stopped producing?
That's my understanding.
And as was just discussed with Mr. Hensley, do you have any understanding, or do you understand that once the plant was shut down in terms of supplying energy to Northwestern, that the plant might have made occasionally other sales of electricity to people other than Northwestern because they'd already reached the contract maximum for that given year? Is that a possibility?
That's a possibility.
Thank you. I have no further questions of this witness.
And neither do I. Thank you. So I think you will temporarily excuse you. Thank you very much. Noticing the hour right here, I want to ask you, do you have any other further witnesses?
So I will say this. So I am prepared to call Mr. Lovejoy. However, so for my purposes, the primary objective of Mr. Lovejoy, other than answering questions, was to discuss the issues relating to section 9.6, which, because Mr. Hensley brought it up with Mr. Collins, we've already handled. And so I have actually no direct of Mr. Lovejoy. So unless the commission or the parties have questions of Mr. Lovejoy, I would ask if we could just skip that. And in which case that would conclude Kelp's direct case.
Objection.
No objection.
So no objection. So then you are resting your case now?
Yeah, if there's no questions for Mr. Lovejoy, at this point, Kelp would rest its direct case.
I think this is admirable. Your sense of timing is totally appropriate right here. Congratulations on that. So we will adjourn for today and reconvene tomorrow morning at 9 o'clock in the same place. We are adjourned.
Thank you.
Thank you.